I'm Lori Kripp Martin, a certified family law specialist and former vice chair of the BHBA litigation section. I'm delighted to introduce our speakers today, Michelle Friend and Anders Sleight. Anders Sleight is a principal attorney and practice group leader of the commercial litigation group at Offit Kurman, with over 10 years of experience representing small businesses, banks, credit unions, property owners, and individuals in litigation matters throughout Virginia and DC. Drawing on his deep familiarity with local courts and judges, he focuses on reaching efficient, fair resolutions in commercial disputes. A Virginia native and real estate enthusiast, Anders also routinely advises clients on real estate matters ranging from buy-sell lease transactions and title disputes to eminent domain and landlord-tenant actions. Michelle B. Friend is a principal attorney with the firm's Los Angeles commercial litigation practice group with over 20 years of experience in matters involving contracts, fiduciary duties, fraud, real estate, business dissolutions, employment, trade secrets, trademarks, and trusts. Michelle also provides general counseling for mid-sized businesses and religious organizations. She has resolved numerous breach of contract actions, employment disputes, and commercial real estate issues. Before practicing law, Michelle was a certified public accountant at a national commercial real estate management company. And now let's get started.
Thanks so much, Lori. Pleasure to see everybody. Well, not see, but be with you all today. Thank you very much. I'm a big fan of the Beverly Hills Bar Association, so grateful to be here today. Anders?
Thank you so much for having us. I'm Anders Sleight. It's nice to be here with my partner, Michelle, and nice to speak to you all. We're looking forward to speaking with you all about business depositions, right? Particularly in the litigation context, strategy pointers, right? We're kind of going to give you an overview of how you want to approach that deposition, whether you're taking it or you're defending it on behalf of your client. So looking forward to your comments and questions. If you have those as we go along, we're happy to field those questions or comments whenever they arise. Don't feel bashful or shy about interposing those, and we'll address them as they go along. Next slide, please.
Yep.
Just a little bit previous slide was just our backgrounds. You heard our backgrounds, but I'm a litigator practicing in Virginia and DC. Been doing it for, at this point, 13 years. So a lot of focus, my focus on business and real estate. I'll let Michelle just briefly touch on her bio, and here's our contact information to the extent you want to get a hold of us.
Yes, thanks, Anders. I am Michelle Friend. I am actually a former president of the barristers of the Beverly Hills Bar back in, I was trying to remember, I think it's 2003. I've been litigating in Los Angeles for almost 27 years now. So, I am it's called the Leadership Council. So I'm one of the leads of the Los Angeles office of our law firm, which is an AmLaw 200 firm based in Maryland. So thank you. Looking forward to presenting with you, Anders. Let's get started.
All right, so any litigator, any trial attorney knows the impact and the importance of depositions, right? But sometimes, clients too often either overlook them or under-prepare for depositions, right? Even maybe in spite of your sage counsel or trying to schedule time to meet and prepare for them. So that's always the tricky part, particularly in a business litigation matter. We've got a client that's busy running their business, dealing with operational problems, right? Maybe having limited time to set aside to prepare for it. But it's absolutely critical and something that we highly encourage you to focus on when you're preparing for a deposition, or to defend a deposition or to take a deposition, right? Treat it like it's, you're getting ready for trial. Don't undersell it. Don't under-prepare because too often these days, cases are resolved short of trial, short of, some type of, court outcome. So, and the deposition can be really the only opportunity maybe for your client to be heard, to tell their story, right? It's an important aspect to any case, is the storytelling aspects. And sometimes that may only come out in deposition, particularly if the matter is resolved before trial. So we want to give you that overview. Of course, you see the code citations here as far as how deposition testimony may be used at trial, right? Inconsistent statements for impeachment purposes or party admissions, right? All of that is fair game. But, I really want to stress the importance of preparation and really using this as an opportunity to frame your case, of course, to obtain additional discovery that may help your case, and critically, if you're defending it, to prepare your client or the witness for what to expect during the deposition.
Yeah, and we're going to approach this from both sides, because business cases are one area of the law where we tend to represent both plaintiffs and defendants, because it just depends on what the issue is. If it's a breach of contract case, that could be either side. In more employment related disputes, you might be more on the defense side. So we're gonna approach it from both directions and give you sort of a broad overview and some more specific examples of both business cases as well. Next slide.
Okay, so just a couple of basics here as far as effective deposition testimony. Of course, number one aspect, and the first thing to tell your client or witness that you're preparing for deposition, testimony has to be truthful, right? It's given under oath under the code section cited right there. Too often that's easily overlooked, but that should be the first and the last thing that you tell the witness that you're preparing for the deposition, right? Tell the truth, right? And then when you wrap up the prep session, remind them of that, because any inaccurate testimony, whether intentional or careless, can cause problems, right? Particularly if it comes out later in the case. And I would also, point out that under the rules of professional conduct, I believe it's rule 3.3, as an attorney, you have an obligation to correct any sort of factual inaccuracies that you're aware of, right? If a witness testifies to something under oath that is untrue, you have a duty to come forward and correct that as an attorney. So truthfulness is number one, right?
Yeah. And I would just, if I could add to that, one thing that I'll find a lot of times with business owners or anyone really preparing for these depositions is they want to, they may not want to tell you everything. And so it's really important to implore them to be fully honest with you in their preparation of the deposition, because you can help them. For number one, there might be documentation or other things out there that they don't know is coming. And if you don't know it's coming, you can't properly prepare them and can't properly defend them in the case. Secondly, you can prepare them for the difficult questions that might arise, where so that they're not put into a position of having to feel like they're going to lie about something. You want them to maintain truthfulness, and you can practice. If you know your weak areas, that's the best way that you can help help defend a person in a deposition, knowing their weaknesses and prepare them really well for those questions that may arise. So it's very important to tell them, hey, look, this is between you and I. Remind them of the attorney-client privilege, and I'm here to help you get through this in the best way that we can. Next point. Yeah.
Absolutely, yeah. Couldn't agree more.
Oh, sorry, I said next point and you went next slide. I apologize. If you could go back, thank you.
Just quickly here on this slide, listening, right? Too often in depositions, witnesses will jump ahead, right? They'll start answering a question before the attorney has finished answering it. So teach your clients to just stop, pause, right? Or if you're preparing a witness for a deposition, teach them to pause before beginning an answer. Let the attorney examining finish their question, and then the witness should go ahead and start answering it. Number one, it gives the witness time to prepare and to consider their answer. The transcript is not going to reflect any type of pause, 2 or 5 seconds before starting the answer, right? It's just going to show the question and the answers. So a witness can take their time in listening to the full question, being prepared to answer it. It also allows time for objections to be interposed if needed. And if you're examining, be flexible in your approach. Don't stick to your script. You should have, a list of topics that you want to, go over with the witness in your deposition. That should be prepared in advance. But, you should be flexible. If the witness gives you an answer and gives you some additional information that you weren't expecting, feel free to explore that. You don't need to stick to, 1, 2, 3 with scripted questions. That's a little bit of an inflexible approach, and might distract from opportunities to learn more during the deposition, which is its principal purpose. Finally, just teach your witness to be concise in their answers. The worst thing that can be done is to answer the question and then go on by providing a lot more detail, a lot more context. And it's very natural for a witness to want to do that, particularly if they're an adverse party to the examining attorney. But then that just gives additional opportunities to the witness or to the examining attorney to explore more areas because they've kind of opened the door. So the best thing to do is to teach the client or the witness to just answer the direct question and nothing more, and be concise.
Yeah, I think that's a really important point, because your goal, I always remind my witnesses, especially folks in leadership roles who are used to wanting to make sure their team understands what they're conveying. And you just really, the point in here is not for the questioning attorney necessarily to understand. It's to give the answer just to the question. So you don't ever want to elaborate if you don't. Even when they really want to, they just, it's best to not elaborate in any context, which is very unnatural and natural in normal conversation. So it's really important to really practice back and forth questioning on things. Next slide, please.
Okay, of course, here are all the requirements and the statutory citations when you're getting ready to notice your deposition. We're not going to go into these in great detail, but of course, when you've got your date and your time, set up, you've confirmed that with opposing counsel or the opposing party, whatever the case may be. You're going to need to set out the date, time, location, whoever the name of the witness that's being deposed, how you're going to record it, right? All of those particulars are important. If you want the witness to bring any documents, with them to the deposition, make sure that you specify that and any categories of records or documents that you're looking for, right? Also, go ahead, Michelle.
I was just going to say, and something unique to California for those litigating in California, required when seeking personal records. There's a section, it's listed here, 1985.3 for consumer records and 1985.6 for employment records. It's really important to send out those notices to consumer to give them an opportunity to object to the deposition or to the documents that may be produced. So when you're looking at this, hone in very specifically on what the definition of consumer is, because sometimes people tend to think it's more expansive than it is. So I'll read it to you. Consumer means any individual, partnership of 5 or fewer persons, so just 5 or fewer persons, association or trust which has transacted business with or has used the services of the witness for whom the witness has acted as an agent or fiduciary. So this may come up in like bank subpoenas and other things. And it talks about the personal records are listed very specifically as well in 1985.31. And it's very specific as to what kind of witness these types of notices are required for. Physician, dentist, ophthalmologist, optometrist, it goes on, medical center, state or national bank, state or federal association, credit union, trust company, things like that. So but sometimes you'll be subpoenaing a party who maybe that you're subpoenaing a bank. And so it falls under that definition of personal records in section 1, 1985.3A1. However, it's not a consumer under the definition of 1985.3A2. So just really pay attention to both as to whether this is required. And then specifically with employment records, people have a right to know whether you are subpoenaing records from their employer, current or former. So follow very carefully the procedures in 1985.6 if you're ever looking for employment records of someone. Okay, next slide, please.
So oftentimes in business litigation matters, you're going to need to depose a non-party witness or subpoena them for records that may be relevant to your case. It could be a financial institution, a bank, as Michelle was just referencing. It could be a competitor or vendor of the opposing party, right? It's a very common witness that you may need to depose in the course of your litigation matter, right? So there are specific statutory rules required for non-party witnesses. Of course, you need to subpoena them, of course. They're not a party to the case. If you want to, get discovery from them, whether it's documents, records, or take their deposition, of course, you need to issue subpoena and have that duly served upon the non-party. Be prepared for pushback or objections from the non-party. It happens all the time, and part of my practice involves, representing non-parties when they receive subpoenas in, the course of their regular day-to-day operations, right? Nobody wants to respond to a subpoena that they don't for a case that they don't have anything to do with. So it's always a common area for arguments and objections. And generally the expectation is to reduce the burden on the non-party, right? Focus on only what matters for that particular case or litigation as it pertains to the non-party, right? So that's why there's, generally speaking, geographic limitations on, how far the non-party witness may be required to travel for the deposition, but always want to keep in mind, reducing that burden on the third party. Number one, it's just good practice. Number two, it helps to avoid any unnecessary disputes over subpoenas to non-parties. And number three, hopefully it will help you get the information and the documents that you may need for your matter. So that's my suggestion when you're dealing with a non-party witness. Michelle, anything to add?
Yeah, I was just going to add, occasionally you'll come across the witness who voluntarily wants to support your case in any way. And regardless, even if they say they're going to show up for trial or show up for a deposition, still issue the subpoena, because there's no requirement for them to come unless they have that subpoena in hand. So regardless of how cooperative they are, it's your client's best friend, whatever it is, it doesn't matter. Always issue that subpoena to them. And, sometimes this comes up in non-party subpoena issues arise in arbitration as well. I've seen that a number of times where folks are trying to get, or in courts where you're issuing subpoenas to out-of-state witnesses or, beyond the 75 miles, and the witness doesn't realize there's limitations. And so they show up anyway, or they think they have to travel from Michigan or wherever, even though it wasn't served, and there might not be jurisdictional things. So if you're on the side of wanting the witness there, you can say go for it and see if they object and if they don't want to come. If you're on the side of, gosh, I really don't want that witness appearing in this trial, then you might want to call up that witness and say, hey, you don't really have to come, even though they issued a subpoena because of whatever reason, limitations there are. So you can play that whatever card, however it best suits your case and your client. But in arbitrations, I've actually seen it go a number of different ways, because the rules are a little different in arbitration. And in some cases, there's been law that says an arbitrator does not have the power to require out-of-state witnesses to appear at an arbitration. But I've had arbitrators do it. So, it's sort of, you don't know exactly what you're going to get. So it's things to consider. So you may get the testimony or the documents that you want, and you may not. You might have to fight for it. Next slide, please. Okay, so employee depositions. If you're representing a plaintiff against an employer, and you're really thinking about what depositions you want to take, there may be witnesses that you have that are former employees, there may be current employees, and there sometimes you really want the high-level executive to be the witness in the case. Sometimes, and I'll go over this in a later slide, but sometimes you're just looking for the person most qualified at the entity. So what you need to do is really think through who it is that you want to testify and what order you want to take the testimony of those witnesses. So for example, you may really want to, maybe you at some point in your case, you want to take the high-level executive's deposition, but maybe you want to take the former employee's deposition first to see what they're going to say, because they're not beholden to that high-level executive anymore. You may want to take a current employee's deposition before the former employee's deposition. You know, it's just thinking through the issues as to why, what might be beneficial is really important when you're planning your case as to what depositions you want to take of the other side. Sometimes, depending on the size of the company, it can be quite difficult to get the deposition of a high-level executive. There will be cases, you know, say I've got a regular just breach of contract case against whatever, Amazon, and I say I'm gonna really get him, and I'm gonna take the president of Amazon over this case, you know, and they're gonna fight you on it, and you may not get it because you have to show there's some sense of necessity to take that because of the level of the executive in the case. The people from Amazon are going to fight you on that. So consider the necessity and the availability of the person. Sometimes oftentimes you can actually, of course, get those depositions, but just think that through, because they will be definitely fighting you on that. When you're taking the deposition of current employees, consider their role in the entity and the supervisors that they have, because they work for the company still. Their testimony will be of a certain flavor depending on who their boss is. Sometimes their boss may be sitting in the room with them. They may be required to follow a certain line of company line, so to speak. And so they may not be as comfortable with you and as honest with you in their preparation or in their depositions when they're taking the case, when you're taking their deposition. So just think of that and really explore those roles. Who is your supervisor? How long have they been your supervisor? You know, if you're the plaintiff taking those, plaintiff's counsel taking those cases, think about that and how they may be affecting that current employee's testimony. Former employees, if you're the one taking the deposition, consider if, first of all, you probably will need to subpoena them sometimes, and we'll get to the defense in a second, but sometimes the lawyers that are defending the company will also defend the former employees, and sometimes they won't. So you'll just have to see how that's going to play out if you're the one taking the deposition. Consider what questions you want to ask them that they will now feel free to answer. And sometimes you'll be really lucky and there'll be someone who will want to say all kinds of stuff about their former employer. And sometimes you will be in a position where they really want to keep their reputation and keep their relationship good with their former employer. So they're very guarded. So in those cases, you really want to, first of all, test the waters to see where they stand as the one taking the deposition. And then also, you know, how long they've been gone, what relationships they still have with the company, really explore all that stuff, and then get into what they do and what they did at the company and the issues in your case. It may be that you take the deposition testimony, and then I've had this happen before. You get later, closer to trial, and all of a sudden they were more willing to toe the company line at the beginning of the case. And then you get closer to the trial and they're not so happy with the former employer anymore. And they want to say all kinds of other things. And so it's kind of good to touch base with those folks if you're the ones taking the deposition. If they're represented by counsel or not, that'll just depend on how you handle that. But they may change the story. Just keep that in mind. So be very prepared when you're going to trial with respect to former employees, that you have really good handle on their deposition testimony so that you are really prepared to impeach them and get them to say other things that you need them to say. Now switching to the defense, when you're representing a high-level executive, like I said earlier, you may want to file some motions and other things to try stop the deposition from moving forward based upon that person's availability and so forth. You may just say they're not available and then let the other person move to compel, and then you can work it out that way. It may be that they have to come testify, which many times they will, but when you're preparing a high-level executive, this is really critical. You have to, they are often so, first of all, busy and don't really have time and don't want to deal with it. You got to make sure they make the time to prepare for their deposition. And secondly, something that's really important is to do role play with them in the deposition, because they are so, I've seen it time and time again, where a high-level executive, they're so comfortable in many circumstances in the boardroom and operations and everything else. But boy, put them in that witness chair and all of a sudden they're sweating. So you just really want to make sure that I highly encourage doing videotape prep with the high-level executive in particular, so that they can see what they look like on camera, really prepare them well, because there's high likelihood that deposition will be recorded, video recorded. You want them to see what they're going to look like. They are the face of the company, and it's critically important that you prepare them extremely well and just tell them, this is your media people are going to want this. Everybody's going to want this. You have to be very prepared. And so current employees, same, again, you're going to want to prepare them for, you may want to prepare them with their supervisors and partially, and then partially not, because you want them to be honest with you. And they got to understand, even though you represent the company, it's important for them to be honest with you, because you don't know what the plaintiff's attorney's the other side's attorney's gonna have. So they need to be prepared, and you need to tell them, look, anything you have to say, you got to tell me now so that we're ready when this comes forward. Just with any other witness, it's really important with a current employee. And sometimes in the preparation, when you're defending a company and you have a current employee, they will start telling you things, and they'll want to know whether you're their lawyer or the company's lawyer. And you've developed a rapport with them, you made them comfortable, which is really important. But it's also important to remember your role. You do not represent the employee as an individual. You represent the company, I'm assuming in this case. So when you represent the entity and the current employee starts telling you things that may be problematic and a conflict of interest for you, you need to be very careful treading that line, and they may need to have separate counsel in some cases. And same thing with former employees. Under the labor code, there are provisions that require an employer to defend a former employee, like say the company gets sued and the former employee gets sued as well. Happens a lot, especially like trade secret cases and other things. So if the former employee is actually a named defendant in the case, it may be okay for you to defend them at the same time, but they may need separate counsel as well. So, and under the labor code, typically the employer is going to be required to provide that separate counsel for them. And you're going to want to address all of these kinds of issues because again, you're defending the entity. And if you have an employee, regardless of what level they are, high level, current, former, if they have some kind of conflict, you need to get them separate counsel. I guess, again, I put on here a subpoena may be required. You can accept service. If you're representing the entity, you can tell counsel, I'll accept service of their subpoena. You don't have to go track them down. I typically will do that. I won't make the other side go subpoena former employees. I'll just accept service for them. So no reason to make it difficult on your professional colleagues, opposing counsel. Anything you wanted to add? I know I said a lot there. Go ahead, Anders.
I think you hit most of the high points. I think just focusing on, kind of the strategy as far as how you want to depose these witnesses, the employee witnesses, in what order. Think about that carefully kind of before you move forward. And don't always think about going for the highest level person first, right? Because And that's where your written discovery, your interrogatories, your document requests are going to be important to inform your decision. Maybe you'll get a sense of, well, this person perhaps is a disgruntled employee, or perhaps they've, may be more willing to share than current employee or the high level, right? So just look at your written discovery, see how that can help inform your deposition decision making.
Great. Next slide, please. Okay, entity deposition. So we talked about, you get to hear me again. We talked about the witness depositions for the entity. Now we're going to talk about the entity deposition. So say you're representing the plaintiff in the case and you want to take the deposition of ABC entity, you're going to issue a subpoena called the person most qualified subpoena, or we often call it the PMQ subpoena. And it's, when you do that, the key thing to do is you have to put in there a description of what the testimony is going to be. So you're saying, I am going to depose the person most qualified at XYZ entity, defendant XYZ entity, or third party XYZ entity, whatever the case may be, and on the topics attached. And then you're going to have a description of the testimony. Either in your notice of deposition or your subpoena, depending if it's a party or non-party entity. And in that, that's the critical piece, is what is the description of testimony? And you want to be broad enough so that you get all the information that you need, but you also need to be narrow or descriptive enough so that the entity knows which person to choose to come and testify, who is the most qualified at the entity to testify about these particular topics. And it's very important for them if you're the person choosing that, because when you're issuing that subpoena to an entity, you don't get to decide who the entity chooses. They decide who's the most qualified. When you're representing the entity in this case, it's really important to consider who is the most qualified to testify on these particular topics. And oftentimes it's not one person. It may be multiple people that have to appear because of the different topic areas, depending on the entity. So oftentimes it's a sort of higher level person that may have, maybe supervising the people who are doing the job of the types of topics you want to talk about, but they'll have the supervising person come in to do the testimony because they're the most qualified to talk about it from a more broad standpoint. So those are the two, that's the really key piece when you're issuing that deposition notice or subpoena of what is the description of the testimony. And when you're preparing the most qualified witness, here's the piece that you're going to really want to think about is go over each area of the description of testimony. So, say there's a list of 10 different things. Look at piece number 1. Okay, I want you to testify about manufacturing these widgets. Okay, I'm the best person to talk about manufacturing of these widgets. What did you have to do to prepare for this? Well, I had to talk to the people on the line and I had to know what, the process was. I need to talk to our billing people or our purchasing people. And, there's a whole scope of people that they might need to get input in just to prepare for that. A lot of it they already know. And that's going to be a distinction that you have to think about in these cases is sometimes the person most qualified to testify is not necessarily the person most knowledgeable on each topic. And that'll come into play later when you're talking about trial testimony. But for when you're taking depositions, it's the person most qualified so that you can get the most information that you can out of a single deposition. Because when you're representing an entity, you typically only want there to be one witness. You don't want to have to bring in 6 different witnesses to talk about things on one entity deposition. Next slide.
So when you're preparing for a deposition, whether you're defending the deposition or you're taking the depositions, preparation is key. It's the most important aspect that you can do in your role as an attorney is to make sure that you are prepared to get the information or to prepare the witness to testify truthfully and appropriately to, for the purposes of your case, right? So I like to start with kind of looking back at what are the elements of the causes of action at issue in your case, right? It could be a breach of contract, trade secrets, or some employment related, causes of action, right? There may be multiple. So start with kind of a decision tree or, breaking it down into the elements of those causes of action and kind of see how that breaks into your questioning, right? If you were the examining attorney, what do you need to cover? What do you need to prove at your trial? Think of it, if you're preparing for the trial, what do you need to prove? What are the facts that you need from that particular witness, or how they fit into that piece of the puzzle, right? Of course, you're going to want to look and review the pleadings, right? The complaint, the answer, anything else, any other motions that might come into play that you could ask the witness about, prior statements, discovery, right? Those are all fair games and good topics that you want to cover with the witness during your examination. So jury instructions, right? Can often be a good place to start because it gives you a good foundation for what you need to prove on that particular claim or disprove if you are the defending on the defense side. So just know your role, know what you need to prove at trial, and that should be the roadmap for what you want to cover during the deposition. If you are, defending the deposition, make sure that you are preparing the witness appropriately. Michelle referenced it earlier. High-level executives, people at organizations and companies, they're busy, right? They've got other things going on. They're dealing with their operations of their business. They don't want to set aside, 2-3 hours or 4 hours to meet with an attorney to prepare for it. They do not, right? It's always a roadblock, always an obstacle. And your role is to educate the client or the witness as best you can about why it's important. Why do we need to set aside this time, right? Because they may think they know everything, but this is not what they do every day, right? Taking depositions or sitting in on depositions, unless it's a super qualified witness, like an expert or somebody like that. So make sure you're setting aside the time to talk to them about, what they can expect, right? Even beyond the substance, right? Just sort of tactics as far as taking a pause before answering, ask for questions to be repeated or rephrased if needed. The use of silence in depositions. And then finally, as Michelle mentioned earlier, take a video, right? If you're going to do a mock deposition, right, take a video and record it, maybe a couple of days in advance of the deposition so that the witness has time to review it, to look at the video and see how they responded to each question, how they kind of acted under pressure, so to speak. I think it could be a really important way to prepare. You're not going to be able to do that in every case, right? It may not, but it's a good idea if you can build in the time and get the witness to set aside that time.
Yeah, and I would say for some businesses, especially closely held and sort of the smaller ones where this is their baby, this business is baby, and they just take it so personally, and they might have a lot of anger, or they might have a lot of I want to screw that person and and they want to prove they're right to the other side. And it's really important to educate them on, this is not trial. This is not your turn to prove your right to the other side. All you're doing is feeding them more information to use against you. So changing that mindset is very important. And don't afraid to be mean. Don't afraid to be mean to your client in your questioning, because the opposing counsel may be asking them really difficult questions in a very pointed and way, oh, you didn't do that? What's wrong with you? In a very accusatory way. You have to prepare your witness for that, and just any kind of strategy that the other side may use. You've got to ask them the tough questions. Don't be easy on your client when you're preparing them. Next slide, please.
Okay, when you're in the role of the examining attorney, right? How should you go about questioning the witness, right? Everybody will have their own style, and that's the number one thing I would say is use the style and approach that suits you best. It's no sense to take on another role or another approach that doesn't necessarily suit your skills effectively. But personally, like when I'm deposing a witness, I like to try to disarm them, right? And some people will do this to try to build up rapport, particularly if it's an opposing party. And they'll start by try to, not be confrontational, at least at the outset, to try to build that rapport and reduce defensiveness. So you need to, if you're on the defending side, you need to prepare your client for that potential approach. I've seen attorneys that take kind of a sort of a dumber role, right? They act dumb during the deposition to try to disarm or try to, act like they don't understand, to get the witness to open up and sort of explain more, right? So coach or teach your clients or your witnesses that, to expect that, right? If it's the opposing party's attorney, they're not your friend, no matter how nice or approachable they may seem during the deposition, because of course, when it comes to trial, the coin may flip and they'll pull out an inconsistent statement from the deposition transcript and use that to impeach you as a witness. So you need to be able to teach the witness to expect that, right? Make sure that they're answering the questions appropriately, truthfully, and concisely, and not, going on as we talked about earlier. As far as the approach, generally speaking, you'll start kind of big picture, right? Start with background, general topics before you think of it like a funnel is what's usually, the usual kind of outline that is done is start big picture, high level, right? And then kind of build down to, a crescendo of whatever your, key elements or your key fact is for your case. And then as the examining attorney, you would move on. If you got a helpful admission, right, from a witness, you don't need to go back to that, right? If they've given you a helpful answer, just know that that's going to be recorded and then move on to another topic. So direct confrontation, can be effective usually later, maybe after you've built up that rapport. And particularly when you're getting down on something very specific, that can be an effective way to approach the witness. Next slide, please. Okay, so what do you do if you're the defending attorney, right? It's not a passive role. You should be actively listening, actively paying attention to the questions asked, right? Of course, and number one is preparing your witness before that deposition to make sure that they understand what to expect, what their role is, and how the process is going to play out. Of course, during the deposition, you need to make sure that you're protecting attorney-client privilege and any other privilege such as work product or trade secrets are inquired into, right? You want to state your objections on the record to any questions. If it's a question that calls for privileged information, it may be appropriate to instruct the witness not to answer as applicable, depending on the context of the question, right? But just make sure that you're keeping an orderly record. Your client, the witness, isn't being abused or badgered during the deposition, right? You need to call for breaks, on a reasonable basis. You're there to kind of make sure that things go smoothly, things go appropriately. The witness is answering the questions. You need to be prepared to step in and counsel or tell the client to answer if they're not being, forthright in their position. And then just protect, any sort of trade secrets, confidential issues that may come up, and assert those objections when you need to. There are, available avenues for relief from the court, protective orders, right? You can file the appropriate motion and put it before the court if an examining attorney is going kind of, beyond what you think is appropriate. That can be addressed later on.
Yeah, and sometimes, people will do things like, I remember once I was, when I first started practicing, I had this very verbose client, and preparing for the deposition, it was just really difficult to get her to not keep talking and want to explain everything. And at one point in the deposition, I just kind of kicked her under the table, and she turned to me on the record and said, "Why'd you kick me?" Oh no, that wasn't a good way to approach it. But really, so that's why you just always preparing, and there's ways that maybe you need to use a break or something to help your client really hone in on, wait, hang on, this isn't your friend. This is a lawyer that's questioning you and using everything that you say against you. So just don't forget that. Next slide.
This is kind of builds off the last slide, and we're not going to go into this in great detail because I think we're running a little bit short on time. But make sure you tell your clients or your witness that you're preparing, right? They can request that the question be rephrased, right? Don't testify as counsel. That's for the witness to do. You're there to state objections, to maintain an orderly process and record, to counsel the witness during breaks as appropriate, but don't testify through the witness. Don't answer the question on the record. Just state your objections and allow the process to move on. If it's a privilege issue, of course, you can assert that and direct the witness not to answer. But yeah, just know your role as the defending attorney. So. And there's, of course, the protective order that we talked about earlier, the code citations there. If you need to avail yourself of that and file a motion with the court as needed, you can always state on the record that you intend to do that. Ask the examining attorney to move on to another line of questioning, and so that you can address that protective order where needed, particularly if it's trade secrets or other things that are involved.
Yeah, I mean, hopefully you can work it out. I have, on rare occasion, had a lawyer just stand up and leave and take their witness with them out during the deposition. But usually you should be able to work that out with counsel. And if you're at an impasse on things, it may be that you need to just switch to a different topic in your questioning and preserve that to file a motion later if there's some kind of bad conduct in a certain area of questioning. Next slide.
Okay. Of course, if any sort of objections need to be raised, right, as far as the form of the question, right, calls for speculation, lack of foundation, right, you want to state those objections on the record. There may be substantive objections to interpose as well, whether it's related to relevance or opinion or other substantive objections. So there's just a handful here. That's not an exhaustive list, but we want to make sure that you are familiar with the categories of objections you may need to raise during the objection to preserve your client's rights down the road. Next slide, please. Okay, so if you have a privilege issue that comes up, that's when you should instruct the witness not to answer. Only when there's a privilege issue is when you should be instructing the witness not to answer. Of course, attorney-client privilege is the big one that comes up. Work product as well, but we've also mentioned, trade secrets or IP-related rights. Those may be where you need to invoke the court, for a motion for a protective order, particularly if there's questioning about a trade secret issue that you think is immune from discovery or subject to a protective order. Then that's where you could try to work it out with the opposing counsel to, have them move on to another line of questioning, state your objection on the record, and then either you work it out or if you need to file a motion on either side for a motion to compel or a motion for the protective order, those rights are in place. So don't instruct the witness not to answer just because it's a bad fact or it's an uncomfortable question. Depositions are uncomfortable by nature. Nobody wants to be there, particularly on the witness side. Nobody wants to be answering the questions. Oftentimes it may be a difficult or an emotional case depending on the facts or the circumstances. That's where you need to prepare the witness in advance, right? Know what the weaknesses are and prepare the witness to answer those questions, right? And you shouldn't object just because it's an uncomfortable, question. Unless a privilege issue, applies or some other objection, the witness should be answering the question.
Next slide.
Okay. One thing that you'll see oftentimes in depositions, and that may be useful for you as an examining attorney, is just to use the power of silence, right? Pregnant pauses. So I've done this frequently where I ask a question, right? Let the witness answer the question and then just pause, right? Sometimes the witness will answer the question. They're trained to answer just that question. But if you sit there and be silent for a few seconds, right? oftentimes the witness will fill the air with silence. So if you're defending the deposition, you want to teach your client, as we've talked about before, just answer the question, be concise in your answer. Don't be afraid to have a room that's silent, because the examining attorney may be using that as an opportunity to get additional information out of you. It works very often. You'd be surprised if you haven't tried it before, but because people just naturally want to fill the air, with words rather than just waiting for the next question. So it can be an effective examination tool. If you're defending, just be prepared and tell your clients about this, or your witness about it, so that they can understand and expect that. Go next slide, please. Okay, of course, during the course of a deposition, reasonable breaks are always allowed, right? So long as a question isn't pending, you can't take a break. Generally speaking, while a question has been pending, you need to answer that. The witness should answer that question, and then the break can be taken. Usually, breaks are going to be about every hour or 90 minutes, but you'll work that out with the opposing party, opposing counsel. Depending on how long you expect the deposition to go, that's something that you should work out, usually off the record, so that you can figure out, well, maybe I've got 30 minutes more, we can push through, or I've got at least another hour. It's a good time to take a break. Make sure that as an attorney, you're not conferring the witness during a pending question, right? Let the witness answer the question. And then if it's time to take a break after that, that's when you can confer with the witness afterwards about what's to come. But those are the limitations you should keep in mind. Next slide, please. Okay, depositions generally going to be limited to 7 hours under section 290. So we have the citation there. So just bear that in mind. If your case falls under these exceptions, you may be able to get more than that, and I'll let Michelle speak on that a little bit more.
Sure. For complex cases, expert witnesses, or agreement of counsel or court order, those are the typical exceptions. There's actually 3 more under 2025-290. A case brought by an employee or applicant or employment against an employer for acts or omissions arising out of or relating to the employment relationship. Those are not limited by the 7 hour. Or any deposition of a person designated as the person most qualified, the PMQ depo that we talked about earlier. And finally, to any party who appeared in the action after a deposition has concluded, then in that case, the new party may notice another deposition subject to the requirements of this section. So those are 3 additional exceptions that sometimes arise. It's interesting with respect to the PMQ depo. I had a case recently where the lawyer they noticed the deposition for the individual that he wanted to depose, and he noticed it for the PMQ. And the PMQ, because it was a closely held business and there's really the same individual is the only guy, he combined the PMQ and the individual deposition together. And normally I wouldn't do that. I would separate them out, because you have unlimited time with the PMQ depo, and you have 7 hours with an individual. So that could cut both ways, because if it's unclear, then maybe you get a long time for the individual depo, because you're not really sure where the PMQ is and where the individual is. But typically I would separate those out and say, this person is testifying now as an individual, and then stop it and start the next deposition for the PMQ. And then the PMQ deposition, as I said before, it doesn't have a time limitation to it. I do see a question on Zoom depositions. So I'm going to just note that for you, Anders. So as we go through this, we will talk about that briefly at the end. So thank you, Larry, for raising that. Go ahead. Do you have anything else on this slide, Anders?
Okay. Next slide.
No?
Yeah, next slide.
Okay. Exhibits. So handling exhibits. Always make sure you organize everything in advance. Ideally, everything is date stamped in advance. It's so time consuming. If you have a stack of documents, to say it's one exhibit and it's 35 pages and they're not numbered, to sit there and maybe there's some of them are numbered internally as they existed natively. But if you don't Bates, it just saves so much time to show up with everything Bates stamped. I have seen counsel that intentionally show up not Bates stamped just because they like to make it more confusing for the other side. I don't find that effective. I find it silly and a waste of time, but I understand some folks find that to be a strategy just to make things more difficult for the other side. Mark them sequentially as you're going through the deposition. So ideally, if you can do it, a really nice way if you're to do your depositions is to go sequentially all the way through. So say you have 10 witnesses between each side of the case. Just start with one and keep going forward. And then if you're in, your third deposition and you want to use an exhibit that was introduced in the first deposition, that's exhibit 1. Go ahead and call it exhibit 1, previously marked in the deposition. Say it was marked in the deposition of, Ms. A, and now we're in the deposition of Mr. B. Then you just say, in Mr. B's deposition, I'd like to now mark what was previously marked as exhibit 1 in Ms. A's deposition in this document. And so just use the same numbering in the same document. So that way it makes it so much easier for trial preparation when you're doing your exhibit lists and everything. That it works out really well if you can keep everything sequentially. So what I typically do is I will actually just keep a notepad with me, or you can type it however your style is, to just have in line what each exhibit is as you're going through every deposition in the case. So I find that to be really helpful. And also make sure that you have copies for counsel and witnesses, and authenticating the exhibits during the deposition is very helpful for our motions in trial as well. So make sure if you're just putting if you're putting an exhibit in front of a witness, make sure they authenticate it while you're sitting there, so that then it's already done and you don't have to worry about it later on. You can use that testimony as the authentication. And preparation of exhibits in advance is particularly important for Zoom depositions, because usually you want to provide all of those exhibits. Ideally, it's very helpful if you can provide the exhibits to the court reporter in advance so that they have everything. And you can even, I often will just email them to counsel that morning of the depo or the day before, just so you have it in hand, so it's all ready to go and you don't waste a bunch of time on the Zoom deposition. And a lot of times I'm doing Zoom depositions with somebody because they're out of the country in another time zone, things like that. So, I've had some recently where the deponent's in the Middle East and they're just in a totally different time zone than us. And the days are flipped. And so when it's 10 o'clock at night for them, and to sit there and try to mess around with exhibits and other things, it isn't helpful. But you have interpreters and you have other things. So it's just really nice to have that all cleaned up and ready to go. There's a question about, speaking of Zoom depositions, if you have a deponent in another country, but it's done over Zoom, do you stipulate that you're applying the rules as though they are domestic? Yes, I do. I apply them under California rules. I don't know, Anders, if you have a different view on that, but
no, that's how I've done it as well.
Yeah. Okay, we're getting really short on time, so if we could zip through the last few. Review. I think the last one was just reviewing the transcript. Make sure they all, just make sure your client knows that they can make changes, but any changes that are made are going to be commented on and they're subject to commenting on later on. So make sure they're important, they really need it. It's better for you if you're really paying attention during the deposition to get them to correct what they said during the depo rather than waiting until later. So that's why it's really important, again, as defense counsel, it's not a passive role, it's active. You got to be constantly thinking. Next slide.
We've spoken before about various motions that you may have to file either after or before the deposition. But of course, the motion to compel, you may have instances where a witness just doesn't appear for the deposition that you've duly noticed. You may have issues related to a witness's refusal to answer certain questions during the deposition that would require a motion to compel. If you have trade secrets or other confidential business information that you need to seek a protection for, that you want to move for a protective order. And finally, kind of last case, if there's a sanctions issue, right, somebody's abusing or misusing the discovery process, or they haven't showed up for a deposition after it was noticed and they were ordered to attend, you may want to move for sanctions. Those can be severe depending on the circumstances of your case.
Yeah. I've had that before. I've seen that where we've had where the party was really, really important and didn't show up to depositions, and so the judge didn't let that person testify at trial at all. So judgment went totally against him for a lot of money. So it's really important to implore upon your client they better show up. Next slide. We're really at time, so we're going to really zoom here. Use of depositions at trial. I'll just say really quickly on this. You really can use them for any purpose, and especially video depositions. I've seen people use them instead of calling the person as a witness in their testimony because you like how the person looks on the camera as an opposing counsel. So you may just never call them and say, you know what, their video is so good for my case, I'm just going to play that video. And so I've seen that a number of times. And of course, it's very powerful in impeachment use as well, or in non-parties where they can't come or the witness is unavailable, they're in another country or whatever. Having that deposition testimony on video is very helpful. I know we're over time, so is there anything quickly we should, if we could just skip through again? Oh, notice to appear trial. I touched upon this briefly. When you have an entity testimony at trial, you're doing the notice to appear. And again, the thing to think about is they're sending the person most qualified to a deposition, but they may not be the person most knowledgeable. So for trial purposes, you do need to notice the testimony of the actual individuals that have personal knowledge. Otherwise, it will be hearsay and you will have problems at trial. So make sure that you have the correct people with actual personal knowledge of the questioning and the areas of testimony that you're going to talk about. Next slide.
We talked about this a little bit before, but just note the ethical rules, rule of professional conduct 3.3, which requires a duty of candor to the tribunal and opposing counsel. So if a witness testifies falsely and you know that as an attorney, you have to disclose that and make sure that the record is corrected. Again, stress to the witness that they need to be testifying truthfully, honestly, completely, and that's the number one duty for a witness in preparing them for a deposition. Next slide, please.
Yeah, I think the rest of our slides you could probably view. I'm cognizant of the time that we're over. So, Anders, I don't know if you have anything specific you wanted to address on these remaining ones. So what I would like to do is just focus a little bit, spend a minute on Zoom depositions because the questions were asked in the chat. When you're preparing for a Zoom deposition, do it on Zoom. Prepare your witness on Zoom. And so they see themselves on camera and tell them where to look, because sometimes we're looking over here, we're looking at a document, and then it's recorded. So you still have to notice the deposition is being recorded or not, because as a video deposition, because just because you're doing it on Zoom doesn't mean it's going to be recorded to be used later, as you are sitting in a conference room with a videographer. So just make sure you put that distinction in your notice. And again, with exhibits, prepare well in advance because you're going to be putting them up on a screen. Practice that so that you're comfortable with putting them on the screen. And when you're defending a Zoom deposition, something to really think about is whether you're going to be sitting in the same room, because you're not going to be on camera with your witness. It's easy when you're live and you're defending a deposition and you're sitting next to your client. But when you're on Zoom, you might be in a completely different building, a different state, whatever the case may be. So you just have to really practice that and prepare for that. Because I have seen some lawyers where they'll be in the same room, or the same location, but maybe in different rooms, because you can't really sit in the same room because you can't be on camera the same, and the microphones don't work properly, and the speakers and so forth if you're sitting in the same room typically. So those would be my key things for Zoom depositions. I don't know, Anders, if you have anything to add to that.
I would just add, absolutely get your exhibits organized in advance, because you want to be able to make sure that you're smooth and streamlined when you're sharing your screen or sharing the exhibits. Definitely, or send them over to opposing counsel in advance. To Heather's point, sometimes things will come up on the fly. You need to be able to adapt, so just be comfortable with that. And lastly, if you're going to play any sort of audio or video during a deposition that you want a witness to authenticate a video or something, you have to share your audio, particularly through Zoom. That's just something I know from experience, because having done it, so just be ready for that. It's a little bit of a two-step process, sharing your screen and then also sharing your audio. So if you're playing anything like that during a Zoom deposition, make sure you focus on that. So any other questions, we're happy to address them. I know we're over time, but so thank you so much for your time, and we're happy to present to you all.
Thanks, everybody.